The First District Court of Appeal is now in session. All who have business before this court draw near. Give attention and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning. Welcome to the First DCA. We have one case on our docket for this morning. That's Luis Del Favero Orchids versus Florida Department of Health, Office of Medical Marijuana Use. Our case number 21-2378. Are counsel for both parties ready to proceed?
Yes, Your Honor.
Please proceed. And Mr. Frazier, before you get started, would you like to reserve some time for rebuttal?
I'd like to reserve four minutes, if I may.
4 minutes, so noted.
May it please the court. I'm Sean Frazier. I'm joined by Kristen Dobson. We represent the appellant Del Favero Orchids. In my first year of law school, I was introduced to legal writing and research and a principle of what laws trump others. Above all else was the Florida Constitution, the law of the land in Florida. Below that, the statutes passed by our Florida legislature, which themselves could only be undone if they were constitutionally infirmed by a higher power. And below that, the delegated authority of the legislature to state agencies to pass rules. Those rules themselves, of course, would be deemed invalid if they violate, modify, or contravene Florida statutes. In the case below, we have turned those orders and hierarchies on their head. And a simple rule that says we are not open for business has trumped requirements of Florida statutes and the Florida Constitution. In 2016, the people of Florida voted for a constitutional amendment that would allow medical marijuana treatment centers to become licensed and offer safe medical marijuana in Florida. They created a deadline in that Constitution to create a Department of Health to register those MMTCs by November of 2017. Shortly thereafter, the legislature enacted a law to enforce the requirements of the Constitution and passed 381.986 and detailed procedures within sub 8 of that law that allowed, again, licensure to be accomplished, again, on deadlines.
Well, can I ask you, you were suing below not just to have DOH issue a license or 6 or 7 licenses, but to deem that Del Favero gets a license, right?
To issue a license based on their failure to act on an application that was complete and filed with the department.
But the suit was not just open up the window that's been closed for years, but open up the window and hand us a license.
That's right, because the window had been closed inappropriately and every other means of legal redress had been exercised and found to no avail. We've been through rule challenges. We've watched in circuit court the constitutionality challenge. We finally just did what the law said was required, filed an application on the form already set forth by the department and completed that form in detail, submitted it for processing, and then got to where our relief brought us.
And the detailed application differentiates this case from MedPure.
Absolutely.
But the issue in MedPure that the window was closed and the Ashbacher limited number of licenses still remain. So Judge Wolf in MedPure gave a lot of reasons why MedPure wasn't entitled to its license. I understand the application was different, but why do we disregard those other things from MedPure?
We suggest the holding turns on the completeness of the application. In MedPure, someone was trying to get away with something. They wrote a letter and said, give me a license. They had no plan, no facilities, and no experience or personnel. It's very different, and there's two distinctions. I think it was dicta to suggest that the rule should trump the statute, and I don't think this court should say that is the law of the land, that because a department says, statute says we have to do something, we're not going to do it. We told you in rule, and that's enough. I don't think is really a precedent. It happened to be the facts of that case. I think they got around to policy procedures. Also, on Ashbacher doctrine and the comparative review principle, it's already been violated by the department repeatedly in this field. MMTCs were supposed to be open for business, and the agency decided not to open the application window, but instead to take lawsuits and approve folks. And when my client insisted, wait, comparative principles, biomedical applications in Ashbacher require that my application be comparatively reviewed, this court said, sorry, no. That principle was not important enough to stop those settlements. So what we've seen is a slew of applications be approved with no application process, no fair game. So for 2 reasons, I think MedPure is distinguished, not just because they were filing a registration letter trying to get away with something, and we're not. We spent $750,000 to buy a citrus processing plant, detailed security plans, experienced personnel, medical professionals, and background checks to show that we were serious about doing business, and then filed a completed application and application fee. Yes, sir.
So you have all of this really hinges on 12060 in the default license. But MedPure pretty explicitly says that 12060 doesn't apply in this circumstance with a need-based licensure. Can you explain why that wouldn't control here?
I'm not sure that is the holding, and there are more than a few precedent that says even when it's a need-based limited licensure situation, unless there's an express exemption from 12060 applies to all state agencies acting on applications. For example, certificate of need laws have an exemption that allows them to escape 120. None was provided here. That's a competitive license. Similarly, parimutuel companies have had default licenses issued. We've seen it in banks where people worry about illiquid banks. We've seen default licenses for chiropractors that'll be treating the medical public. In every instance, there really is no excuse to avoid 120.60.
I'm sorry, do any of those examples you gave involve limited number? Licenses are limited in number?
In the CON arena, yes, but I have to admit that has an exemption from 12060 that is express. Well, I'll give you another example, and that's the Del Favro appellate case that we've already seen. Those involved licenses for a limited number, medical marijuana treatment center licenses like the one we seek here, but this court said biomedical applications wasn't important enough to stop the settlements that gave away licenses that my client wanted to compete for.
Did that case fall under 12060 sub 1?
That case was...
Did it consider?
It was under the Appellate Administrative Procedure Act. We tried to intervene to prevent the issuance of licenses. What happened was the agency denied licenses, rightfully so, incomplete, terrible applications, went into litigation, and then and unbeknownst to anybody, no one knew about the litigation, and then settled the cases. Once those final orders came out, we tried to challenge them. So it wasn't 12060. They were arguing their merits and wound up in settling. It was 120.57 for us 4. In any event, the biomedical application comparative review principle was unimportant to this case, the court.
The number of licenses, it's still the same as mentioned in the Florida Supreme Court Flora grown? Are there 7 that are available?
It's grown under 3D1.986.8E. There's several licenses. First, Pigford, 1 license for black pharma class action, then another 10, and then another 4 for every 100,000 users that are registered to get medical marijuana. According to the department's website last night, there are 19 licenses available, none of which can be applied for even today.
And are you aware of anyone suing just to open the window as opposed to open the window and hand me a license?
I'm not aware. There have been a ton of lawsuits, including the constitutionality of the law, but I'm not aware of anybody else trying to petition for administrative relief to open the window, but it might be inappropriate. If you ask for that relief, it would be under 120.56 to initiate rulemaking, sub 7. Please issue a rule that says open the application for process.
Well, I mean, is there not a constitutional claim under Article 10 that gives, any aggrieved citizen basically standing to sue?
Could do it that way again, but I think you'd wind up with I think that the constitutional provision, as the court cited below, calls for a declaratory judgment action, not a forced rulemaking. So, and I'm not sure I'm not sure the correct remedy, if it wasn't mandamus and declaratory judgment like we saw below, I'm not sure what else you could do to compel the court. But in any event, that's not our case. Our case is that we filed an application that was complete, and the real question before the court is, what excuse does that department have to avoid 120? When the law that governs licensure says you shall issue a license, as this court noted in the RC opinion, that means the department shall issue a license by the deadlines set forth in that law. They must follow that law.
Well, there's no limit on the number of concealed carry permits. It's a little different here.
There is not, but again, I'm not sure how you can say that the comparative principles must apply when there is no process for comparison. What we're really dealing with is what 12060 enforces and says this court must do. When an application refuses to do its job, ignores applications, and doesn't even tell you it's incomplete or I'm not taking it, and just sits on it, the remedy is clear.
But, well, that's not quite right. I mean, you have a rule that's been promulgated that says that a window will be published, right? You don't like that rule and are suggesting that it's perhaps inconsistent with either the statute or the Constitution, but there's a rule that's been promulgated that says that, right?
It's invalid on its face, and the remedy set forth in the Constitution is to go to circuit court.
But you're not
to challenge that rule.
But you're not challenging. You're not challenging the rule. You're wanting a default license under 12060.
Yeah, if I went and challenged the rule, I would have been dismissed out of hand because the relief offered by the Constitution is the relief that MedPure didn't seek. They went through the Administrative Procedure Act and said, that's not the right place. You have to go through the Constitution and through circuit courts as we did. So I could have filed a rule challenge, played in that arena for some time, but it really wouldn't have provided any relief in terms of actually issuing a license or opening the process. It's, I think, futile. We're now 5 years after the Constitution said licenses must be issued. 4 years after the legislature said the same thing. To suggest that we now have to go through other hoops. I've been through the rule challenge proceeding, and we won, and even got attorney's fees that were reversed, trying to enforce the agency and make a fair process to let us all apply. They've pointed to those lawsuits and said, now we can't even have a process because the lawyers are gumming it up. We've been and exhausted and realized the futility of all the Administrative Procedure Act remedies, which pains me as an APA lawyer. The only remedy that's available in the Constitution is the one we sought, to get mandamus and a declaratory judgment for a ministerial act that the department has now waived its discretion on by failing to act on our application. I think I'm almost out of my time. Unless there's other questions, I'll reserve the balance.
Thank you, counsel.
Thank you.
Good morning, and may it please the court. I'm Amber Nunnally from Schutz & Bowen. I'm joined at counsel's table by Jason Gonzalez, and we're here today on behalf of the Florida Department of Health. The issue before you is simple. You've already identified that through your question so far. It's whether the trial court properly dismissed Del Favero's complaint with prejudice when it was seeking a default MMTC license, and whether that decision was properly based on this court's decision in MedPure. The answer is yes. That was a correct decision, and for two reasons, it should be affirmed. First, Del Favero's purported MMTC application was submitted during a time the department was not accepting applications. And second, the department is not authorized to issue MMTC licenses outside of a comparative review process. This court's decision in MedPure is directly on point, and it controls the outcome of this case. Based on MedPure, Del Favero is not entitled to a default MMTC license under 120.60. That decision has been applied 5 times to other factually similar cases since April 2020. It's legally sound, and it must also be applied in this case. I wanted to
Do any of those other cases involve a completed application under your own rules, or are they more like MedPure, where they just simply wrote a letter to the department demanding a license?
There are 3 other cases of the 5.
Are any of them reported?
Excuse me?
Are any of them reported?
They're decisions that were affirmed with citation to MedPure. Is that what your question was?
Yes.
Okay. So there are 3 of those cases that are factually similar to the circumstance of this case. In 3 of those other cases, the entities that were seeking a default MMTC license did complete a purported application on a form that was promulgated by the department under the emergency rule. And all 3 of those cases were affirmed. The dismissal of those cases were affirmed with citation to MedPure.
Well, I was on the MedPure panel, as y'all probably know, and I went back in preparing for this and watched the video of the oral argument. During that oral argument, counsel for the department said they were preparing to open the window, just have to get Florida grown out of the way, and then the window's going to open. Florida grown was decided by the Supreme Court a year ago, and the window still hadn't opened. So, I mean, what more does somebody have to do to be able to get a license?
Well, Your Honor, the process that the department has been going through since Flora-Grown was issued is in April 2021 is not a part of the record in this case. But I am aware that the department has issued a rule in October 2021. They issued a rule to open an application window for one of the 23 currently
the black
available
farmers,
licenses.
I mean, but that's a very specific class, right? I mean, there not many people are eligible for that.
Right.
This is more for the general window and the citrus processors preference. You know, what's the department said that's coming up and said that to us 2 years ago. And it's still, I mean, I think that's one of their main complaints is, what do we got to do to get this going?
I understand that that's one of the complaints, and today they are trying to turn this case into what the department may have done or not done with respects to implementing the amendment, but that's not the claim that they brought in the trial court, and they've never sought to amend their complaint to bring a claim to force the department to open an application window or take some other action that they think they were required to do under the amendment or the statute. The claim that they brought in the trial court was simply for a declaratory judgment that they are entitled to a default MMTC license as a matter of law, and then to order the department to give them that license immediately. I think that Mr. Frazier might have stated earlier that they were attempting to have the trial court order the department to open an application window. That was not a part of their complaint below. They did not ask the department to be ordered to open an application window. They wanted the immediate issuance of a default MMTC license, which this court has already decided in MedPure is not required when someone purports to apply for an MMTC license at a time that the department is not accepting those licenses.
Can I ask you about MedPure? One of the Judge Wolf's key factors, I think, was Ashbacher and the comparative review. Del Favero says there's been a number of licenses issued without comparative review here. So why do we have to go through comparative review if a number of other people got an MMTC without comparative review?
Well, first to clarify the previous case that Del Favero brought related to the settlement agreement, the court in that case did not say that there was some violation of Ashbacher or that it didn't, the Ashbacher doctrine didn't matter. The court in that case simply said that Del Favero did not have standing to challenge the settlement agreement. So I wanted to make sure that was clarified. But even if that issue were properly before the court, even if Mr. Del Favero had standing now to challenge the settlement agreements, the department didn't violate Ashbacher by entering into those 8 settlement agreements because those entities were not given licenses by default under 120.60. They received settlement licenses after they had already gone through a comparative review process when they applied to be dispensing organizations, which are the precursors to MMTCs. They were previously reviewed, evaluated, and scored by the department, and it was determined that they met the core requirements for licensure. So to date, the department has never issued a license to an MMTC that has not gone through a comparative review process.
Can I bring you back to 12060? Is there ever a time where 12060 could be properly applied to a competitive limited license situation?
I think that based on this court's decision in MedPure, that's probably very unlikely that anyone could get a license by default under 120.60 when the licenses can only be issued after a competitive or a comparative review process. So turning back to Mr. Frazier's attempt to distinguish Del Favero's purported application from MedPure's. MedPure and Del Favero both submitted their purported MMTC applications to the department within days of each other in October 2018. And Del Favero tries to distinguish itself from MedPure by relying on the fact that it submitted a purported application on a form that the department had promulgated through the emergency rule instead of just a letter like MedPure did. But that's a distinction without a difference, and it does not change the outcome of this case. This court was clear in MedPure that the department has no legal duty to issue a default MMTC license when a purported application is submitted at a time that the department has notified the public that applications are not being accepted. Del Favero has focused only on the fact that MedPure submitted a bare bones filing, but this court rejected MedPure's purported application as both incomplete and unauthorized. Not just that it was a bare bones filing. Just like MedPure, Del Favero submitted a purported application to the department at a time that it was not accepting applications. Therefore, the result in this case has to be the same. And we've already discussed the Ashbacher Doctrine, where the court determines that the Ashbacher Doctrine prevents applying the default license provision in 120.60 to competitive licensing schemes like the one in 381.986. They have argued that Ashbacker doesn't apply here when the department simply refuses to take action. But that argument, again, misses the point from MedPure that a default MMTC license is not available when you submit a purported application at the time that the department is not accepting applications. The process that Delphi Vero advocates for would create an unconstitutional first-come, first-served system where the timing of an application and not its merits drives the licensure process. But the department has a constitutional duty to ensure the availability and safe use of medical marijuana, and it cannot meet this duty without engaging in a comparative review of competing applications. Mr. Frazier has also suggested that the department should recede from MedPure. We respectfully believe that he has not raised any valid reason for the court to recede from MedPure, and of course the court could not do so unless they were sitting en banc. So the department would request, if the court chooses to go en banc to review its decision in MedPure, that we be given further opportunity to brief that issue. And if there are no further questions, we would ask that you please affirm the trial court's order dismissing the complaint with prejudice. Thank you.
Thank you, counsel.
Thank you, Your Honor. I'd like to begin with a correction. There is one comparative example. It was a CON case, and I'll explain my confusion. The Naples Community Hospital case cited within our brief provides an example of an application filed for comparative review under the Certificate of Need process, where the agency failed to act on a recommended order and was suffered the default provision of 120.60. That amplifies the fact that 120.60 has no exceptions. There are no exceptions for applications that happen to be comparatively reviewed with others. There's no exceptions for applications that purportedly are incomplete or not complete if the agency fails to tell you that they're not complete. All of this could have been avoided if the agency simply did its job and acted on the application in some form. We've seen no excuse other than an agency rule, which is clearly invalid on its face, for why the agency failed to do its ministerial duty to at least acknowledge the application and tell us it's incomplete or untimely. Failing to do that, we resort to 120.60, and that is the law of the land. Default licenses must be issued, even when policy proceedings suggest that's not a good idea. Maybe to give an illiquid bank a license to take people's money, or a doctor who might not be qualified to go serve the public. In those instances, 120.60 says that doesn't matter. The agency had a duty. This law enforces that duty. We're in the same situation today. There are lots of folks that might want to apply for MMTC licenses. There'll be lots of licenses available for them when, if ever, the agency opens up a window. We're not unfairly prejudicing anybody, and we're not trying to get away with anything. We have a serious applicant that came to Florida and thought there was a fair game, and it's up to this court to decide that it really was a fair game, that applications are possible without any undue influence. We suggest that any dangers that the court might have or concerns about dangers are should be not really of a concern, because if licensed under 381.90b6, this MMTC will be subject to all the safety concerns, all the product concerns, everything that the agency can do to regulate the safety of MMTCs. So we're not trying to get away with a thing. We're really just looking for a square game and a fair chance to serve the public in the way the Constitution and the statutes say that we're entitled to. Thank you again for your time.
Thank you, counsel. Thank you both for the argument. The case is submitted, and with that, the court is adjourned.
All rise.